I'm Lonnie Alcino, and I work here in the Office of Development as our giving officer. And I'm here with David Sykes. He's an attorney at law here in Fairfield, Iowa. So David, can you tell us a little bit about what courts you practice in?
Well, I originally was admitted to practice in Maryland, where I went to law school there and got my Juris Doctorate of Law. And since moving to Iowa, I have gotten my law license here in Iowa, and I can practice in all of the Iowa district courts. I'm admitted to practice before the Iowa Supreme Court, also federal courts in Iowa, and the federal bankruptcy courts.
So David, would you mind telling us a bit about the estate planning process?
It'd be my pleasure. I've been very concerned in the last few years talking with clients, the misunderstanding that they seem to have in terms of a will, a trust, probate, and so forth. So I've been doing seminars as a courtesy in the community. Essentially, most people are familiar with a will. And a will is as old as time, and it's a way to pass your assets to your loved ones and beneficiaries. In our modern society, if you have a will only, however, in Iowa and in many states, it means that your estate, when the person passes, it will go to probate. Probate is actually a district court where a person resides, where a judge will have to hear the presentation of the person's estate, creditors, beneficiaries, accounting. It can take anywhere from 3 to 12 months. There are significant fees and costs. The attorneys involved usually get a percentage of the estate, which can, depending on the size of the estate, could be a very sizable amount of money. Very few people seem to understand that if during their lifetime they also create a trust that would go hand in hand with the will, that if properly executed and documented, you can avoid probate completely. And then when the loved one passes on, which is just an inevitable situation, all of their assets would pass automatically without the need for probate, lawyers, expensive cost, the stress of putting loved ones through a long probate process. And so I've been on a mission, if you will, to educate people so that they can at least have an informed understanding. So my estate planning process involves a will, and the will, among other things, actually empowers the creation of the trust. Sure. The trust would be revocable during the person's lifetime, meaning that it's their trust, and they would even be the trustee of the trust while they are alive. But when they pass, the trust would become irrevocable. In other words, the last format of that trust before the person passes would then become locked in stone, so to speak, so that their successor trustees and their beneficiaries receive exactly what that person's last wish was. The other two documents that I find also important would be a living will and a medical power of attorney. A medical power of attorney, as most people understand, is that it's not necessarily a life-threatening situation, but let's say you're in the hospital temporarily unable to speak for yourself. By choosing a medical advocate and actually writing it down, it allows you to feel more comfortable that somebody who knows you well will be taking care of you, dealing with the doctors, etc., for that temporary period when you're not available. The living will is a bit more serious. It's a document when someone is not expected to recover. They could be on life support type of programs. And the question is, what is their wish in terms of remaining on life support or not? And also, they would choose a medical advocate, a living will advocate, who could speak for them if, in this case, they were not able to speak for themselves. So the process would be sitting with people, understanding their assets, understanding their needs, what they'd like to do to protect their loved ones, and dealing with the will, and the trust, which by definition will bypass probate, which is, I think, advisable in today's culture.
So I've heard that a lot of people have wills, and so they think that they're completely covered. But I know you say something a little bit different, something about needing a trust accompanying the will.
Yes, I think you're right, that most people, just through common understanding and education from the environment, talking to people, believe that if they have a will, that's it. They've done the right thing by their loved ones, and that's the end of the matter. What they don't realize is that a will by itself automatically demands and is required by law that the estate go through the full legal probate process in a court with a judge, and a lawyer is needed, and it could go anywhere from, as I said a few moments ago, 3 to 12 months before the probate estate is finished. And all that time, your loved ones, at a very vulnerable time in their life, have to suddenly start dealing with this legal process.
So if you have a trust, you completely avoid the legal process?
Well, you wouldn't completely avoid the legal process, but you would, if properly executed, avoid probate completely. And that means it's still a difficult time when a loved one passes, but at this point, everything had been planned ahead of time. The probate and all of the public nature of it and the stress of it is avoided. So it minimizes the impact on loved ones at that time. So I think it's very important, at least from my point of view, that people understand this and they make informed decisions. That's my goal.
So how would you say charitable giving plays into estate planning?
Well, I think people of means, first they want to take care of their family and their loved ones. But in some cases, people have acquired enough wealth in their lifetime that over and above their family, they are in a position to leave money to charities or foundations that they feel are doing good work, or they want to support the work of something that is very important to them. So in the planning process, it's not uncommon when we're talking about the beneficiaries that a beneficiary of a person's estate, let's say in the trust, could be a charitable foundation, an educational foundation. And again, it can be done relatively simply once the wishes of the person are known, and it could be worked into the estate planning process fairly easily.
David, I also heard that you wrote an article that was very interesting back in law school.
Well, actually I did. In my senior year, I wrote a thesis that was entitled Transcendental Meditation, the Criminal Justice System and Society in General. And it turned out it was published as the feature article in the Maryland Law Forum. And back in the day, a gentleman named Curly Smith, who was one of the early leaders of the TM movement, gave a grant to the law school paper and had copies of the article sent to all members of the executive branch of government, including the president, all members of Congress, the House and Senate, and all members of the judiciary. And it was, from what I understood, it was the first time a legal paper had been published talking about transcendental meditation in the United States. And then years later, I found out that the article was quoted in a criminal case that was heard before the Supreme Court of India. And I found that fascinating. And it all started, I was invited to meet with Maharishi in 1972 in New York, where he was presented with a copy of my law school paper. And later, the movement asked for reprint rights, which it received, and it was one of the handouts given at intro lectures for many years. So I was very excited, and it was my honor to do that way back in the day.
That's great, and you're still involved in doing things for the public, and I hear that you are the chairman of the board for Noah's Ark.
Well, yes, I was involved in founding Noah's Ark about 23 years ago, and the organization has gone through a lot of growth pains and whatever, but right now it's doing really well. And I'm proud to say that Noah's Ark, which is a model mid-sized center, is saving about 800 dogs and cats a year, helping them get homes, rescuing them, sponsoring neuter spay programs. We have visitors from around the United States, and they come to Fairfield.
So what exactly inspired you to do these free seminars?
Well, I tell you, I've been doing legal estate planning for quite a few years. And more recently, I received phone calls from families where a loved one had passed, and they called me at a very emotional time. In one case, one of the loved ones had a will, and in one case, they did not have a will. And in both cases, the family that called me asked me if there's anything I can do to help them. They were going through the grieving process. Everything was coming at them very quickly, and I had to tell them, now that their loved one had passed, there was very little I could do. The door had closed, if you will. The person without the will, by definition, the entire estate, which in this case was a reasonable amount of money, had to go to probate. And since there was no will, then an Iowa statute steps in and essentially creates a statutory will of how the person's assets are to be given out, trying to replicate what a fair will would do, which sometimes may or may not be what they really wanted. And then in the second case, where the person passed and they did have a will, the family was not aware that they suddenly had to now go through the probate process. They were very unfamiliar with it. They were in a state of distress. And when they called me, I realized that this is prevalent, that there are a lot of people in this boat that were not aware that a simple trust, a planning process could not only avoid probate and all this stress, but it actually would save thousands and thousands of dollars to do the right thing. And so I decided I was going to do some free seminars in our community and at least inform people what the truth of this matter is, how it really works, so they can make informed decisions. And in I hope many cases, have them do the planning in advance. And so then if these times do happen, it's going to minimize the impact on the family and the loved ones at a very tender time in their life.